So if I understand your answer, and I'm sorry to interrupt you, but I just want to make sure I understand. 1331 grants jurisdiction to district courts. The FTC Act grants jurisdiction to courts of appeals for cease and desist orders. There's no withdrawal jurisdiction anywhere in those statutes, and so you ask us to turn to the APA to discern that. Is that right?
Well, we're asking,
is that your argument?
I think the APA confirms that the provision governing review of final cease and desist orders is intended to cover not only the final order itself, but any challenge to the manner in which the proceeding was.
So we're on to the APA now. We're past the FTC Act. And what do you say first to the argument that contention by the government was forfeited or waived? And second, what do you say to the argument that the sentence you're pointing to in 704 speaks to an agency action that's not directly reviewable, is subject to review on the final agency order, final agency action? And an agency action is defined as a rule, an order, a license, a sanction, or relief, and we have none of those things here. So we don't have agency action. What do you say to those two arguments?
I think as to the first point, I don't think that our Court of Appeals brief quoted this specific sentence from the APA. We did make the argument in the Court of Appeals that what they are challenging is not final agency action to begin with, because under Standard Oil, the commencement of agency proceedings is not reviewable at all. So that argument has been preserved. The second thing I would say is I think that agency action is at issue in this case. That as Mr. Clement said, what we're really challenging is the composition of the agency or the question of whether it's constitutionally structured. But obviously, as a matter of Article 3, a plaintiff couldn't get into court simply by saying the relevant statutory...
I'm not concerned about what the plaintiff's saying. I'm concerned about where is the agency action that would implicate 704. That 704, the sentence you rely on, speaks of agency action being reviewable upon the final order.
In this case...
Where is the agency action under 551, I think it's paragraph 13, maybe? It defines agency action, and I'm just struggling to see where that's present in this case.
In this case, it is the commencement of the FTC's administrative adjudication, the commencement by the FTC, and the assignment of that proceeding to an ALJ. And the point I was making is a plaintiff can't get into court simply by saying the statute is unconstitutional because the agency is improperly structured. In order to have Article 3 standing, the plaintiff would have to say the agency is doing something or is about to do something that injures me. And in this case, the thing that the agency was about to do, because as Mr. Clement said, the suit was filed a few hours before the proceeding was commenced, the thing that Mr. Clement is complaining about is the fact that an administrative adjudication was commenced. Had there been no adjudication commenced, perhaps Axon could have found other...
Do we have here a rule, an order, a license, a sanction, or relief?
Well, the whole thing that we don't have that, and that's
we don't have any of those things.
But that is why we don't have final agency action. But
well, we can have an interim order. There are all sorts of interim orders and interim relief that an agency could grant to constitute agency action under that definition.
If the Commission had given no indication that it intended to commence an administrative adjudication against Axon, then Axon would clearly have lacked standing to raise the claim that the ALJs were improperly insulated from removal.
Let me see if I just have a summary of it. Textually, for putting aside other things. We don't have anything in the FTC Act. We don't have anything in 1331. We have to go to the APA. We have to find that you didn't waive it, and we have to agree with your understanding of what an agency action is. Is that right?
Well, you certainly have to agree that a plaintiff needs to identify an agency action in order to challenge the composition or structure of the agency. But I think that is basic administrative law. I don't think any litigant or justice on the court would say that the...
I'm going to take that as a yes.